Thank you. Thank you, Dr. Bryant. Thank you. So if you're having problems hearing me, if you would please move up closer, I'd appreciate it. We're going to have a microphone connected hopefully at some time. I want to thank Dr. Bryant and her staff at ISD for having me and hosting Donna and I this morning, and for lunch. It was a wonderful lunch. So I'm thrilled to be back here on campus. It's been a while, since 1989. I have to share with you that last year I was at my gym in Glenview, Illinois, and there was a young man walking around working out in a University of Southern Mississippi t-shirt. I'm thinking, wait a minute, that's my t-shirt. What's the guy doing with my t-shirt? I haven't seen anybody with Southern Mississippi up there. And so I stopped and talked to him, and he happened to be a junior here, and he was interning with Allstate. And he mentioned to me that the university was very active in the last couple of years of trying to place students all over the country, and it just so happened that he was up in Glenview. So it was exciting to see a bit of Hattiesburg up there in Glenview, Illinois. So I'm thrilled that you're here and to listen to me talk about the road to equality of opportunity and full inclusion. What this is nothing more than a history of the disability rights movement. Not only a history, but also I want to talk about where we're headed in the movement itself. And I want to make this as informal as possible. So I'll be asking questions of you. So throughout the afternoon, please ask questions of me. I want to share with you that last September, I participated in the Pikes Peak Challenge. That's a climb up Pikes Peak Mountain in Colorado Springs, from 7,300 feet at its base to 14,100 feet to the summit. It took me just over 6 hours to get to the top. Now, while everybody else made their way up the mountain, I went up Pikes Peak Highway, as you can see here. And I said it just took me over 6 hours to participate. There were 300 participants. I was the only one in a wheelchair, and as you can see, in a manual wheelchair. I recruited my son, my brothers, and friends to come with me. And, okay, my beautiful bride, Donna, who's in the back, insisted they come with me. Because as you can see, there's portions of the road, there was no guardrails, and the shoulder, very little shoulder, and the road just seemed to disappear. It was nothing but clouds and sky and no mountain. Now, the highway that I was on was created first in 1904. It wasn't until 2011 where it became fully paved. Were it not paved, I don't know that I would be able to participate, let alone reach the summit. Before I started going up the road, I was adamant with my crew that no one was going to touch the wheelchair. I was intent on doing it alone. But after the first 4 miles, what I found is that I had more energy fighting to keep my chair straight than moving forward. The pitch at times was so severe it would slant into the mountains, and other times outside of the mountain, away from the mountain. And because there was no guardrails, there was a real fear in some stretches that I'd simply just fall off the mountain. So I admitted reluctantly, I think what I knew all along, but stubbornly didn't want to admit, and that was that I couldn't do it alone. I needed assistance getting up the mountain. I was grateful that I had my crew with me. Now, the climb was absolutely amazing. The views were breathtaking. You get a sense for what it was like in this photograph here. And that is when I dared look. Now, I'm not scared of heights. I've been high many times before, but certainly not to that degree of 14,100 feet. But what was scary is, again, there was portions of the road where there should have been guardrails. If you're going to pave the road, make sure there's guardrails all over, but there weren't. And so, again, the mountain just seemed to disappear, and nothing but clouds and sky. Upon reflection, though, that highway is in many respects a metaphor for the disability journey that I'm on, a journey made possible by the passage of the Americans with Disabilities Act in 1990. When the Americans with Disabilities Act was enacted in 1990, it paved the road to equality of opportunity and full inclusion. But it doesn't guarantee it. As you can see, and what we'll talk about later this afternoon, there are portions of the Act where there should be guardrails, and that is very robust language and robust enforcement to help keep people safe along their journey, their disability journey, but they're simply not. And while the ADA permits for full inclusion for millions of people with disabilities, as we'll talk about it, it doesn't guarantee it. And what I've learned over the past 19 years since I've joined this community is that the road to equality of opportunity and full inclusion is long and seemingly never-ending. The road to equality of opportunity and full inclusion is steep and is pitched. The road to equality of opportunity and full inclusion has many curves and few straightaways. In the absence of irrefutable language in the Americans with Disabilities Act and its robust enforcement, the road to equality of opportunity and full inclusion requires guardrails, human guardrails, advocates and individuals interested in people with disabilities to keep us safe on this road and along this journey. But why should that matter to you? There are 56.7 million people with disabilities in the United States. 19% of our population, or 1 out of 5 of us, report having a disability. Disability is becoming so prevalent that soon every family will be touched by some form of disability, whether it's an immediate family member or a distant relative. We will all be able to say that we know somebody with a disability. And from my perspective, that's good, because it's only when a disability becomes personal is that when I see people interested in getting involved. And that's what we need. People take a personal stake in what disability means and what disability issues are in order for things to get changed. If we were to be viewed as a minority group, which we're not, we'd be the largest minority group in the country. And by far, we're the most welcoming. We don't discriminate. We accept anybody of different religions, of different races, of different gender, socioeconomic status. Hundreds join us daily, many times unexpectedly, as in my case. 19 years ago, I joined this beautiful community as a result of a car accident. Within a fraction of a second, I broke my neck and sustained a spinal cord injury, resulting in quadriplegia. My life changed within a fraction of a second, and so did that of my family. And what we have to realize is that the struggle for disability and the disability issues not only affect the person with disability, but it also affects the family and also affects the community, and that's why you should be interested. Now, our struggle in the disability journey is not unique. When you just look at these headlines, you see that other groups are also struggling for inclusion and equal opportunity as well. From Washington, D.C., from Seattle, and from Dallas. These are recent headlines, just happening this year. How does it make you feel? What's your reaction to any of these headlines? Sorry? Awful? Any other reactions? Anger. At what part? The injustice, discrimination? Anyone else? It's unacceptable. It frankly pisses me off. It angers me to no end that in 2015, we're telling people because you're Jewish you can't apply, because you're gay you won't be served, because you're black you can't ride in Uber or participate in any of their homes in Airbnb. It's just totally unacceptable. What I find, though, is that when this type of discrimination occurs for people with disability, the level of anger is not really at a level that equates to when we talk about races, gender, or religion. Now, these headlines are true except in one respect. I substitute a person with disabilities with Jews, with blacks, and with gays. Because these things that we're going to talk about, these headlines, we're going to come back to them a little bit, but they're occurring today for people with disabilities. And again, the level of anger in the public is not quite at the level as you see when we talk about Jews, blacks, or any other minority groups. For one reason, there just seems to be a general indifference when it comes to these things occurring for people with disabilities. I used to think that it didn't matter how people who weren't disabled thought about us. But I've come to change my mind on that because it does make a difference. It's important how society views people with disabilities. As the 18th century German poet Johann Wolfgang von Goethe said, that how you see people is how you treat them, and how you treat them is what they become. How you see people is how you treat them, and how you treat them is what they become. And I firmly believe that to be true. Until the day comes where persons with disabilities are more visible on boards of directors, in C-suites, in highest levels of government, so that we can be a constant reminder that we're here and that we need to be accounted for, and that the policies that are being implemented need to be designed to take people with disabilities in mind, we have to be concerned about how we're viewed. Models of disabilities have been developed, and they serve for tools for defining how impairment is going to be treated in society and how society is going to interact with people with disabilities, and conversely, how people with disabilities are going to interact within society itself. One of the first models of disability was a religious model of disability. And this had a view that if you were born disabled, it's because of a defect, because you're being punished. You're being punished because something a family member did either in a prior life or in a recent past. That disability is viewed to be a defect for which it's punished. That because you had a disability, it means perhaps that there was evil present. This is certainly true to explain epilepsy or schizophrenia. It was evil, and evil had to be treated either by social exclusion, by death, or through exorcism. That individuals maybe had to be sacrificed in order to be treated. People with disabilities using religious models back in the 1800s had zero value to society. All they did was drain the resources of society. And as a result, that's how people treated those with disabilities and their family members. That the individuals who had a disability were different and had to be persecuted. Some religions, some cultures here today still cling to this model and still treat individuals with disabilities in this regard. In the 1860s, the charity model emerged. This model tended to look at persons with disabilities as being a problem to the community. Because back in the 1860s, the state wasn't created to take care of people with disabilities. If a person with disability was born into community, that was the community's or the village's problem. As such, the village had to rally around, the community had to rally and take care of this individual if they're going to be taken care of at all. So it was a drain upon the resources of a particular community. But the charity model views individuals as being incapable of taking care of themselves. Others would have to do things for us. Others would make decisions for us. Others would care for us. We were incapable of making decisions for ourselves. The charity model still exists today in many respects. Today, charities use this model to try to raise funds for their particular cause. And while that may be very helpful to display people as being disabled, as being not able to care for themselves, while it may be good for fundraising, it takes away from the dignity and the importance of the individual themselves. Okay? It viewed that individuals should be pitied. In 19 years since I sustained my spinal cord injury, I can rarely remember an encounter where somebody expressed pity for me. When they find out I'm an attorney, dude, you're a lawyer? I'm so sorry to hear. How'd that happen? You poor guy. There's a cure for that. You can stop. That's when I hear pity. Yes, sir. There's a cure for being a lawyer. It means turn your bar membership in. That's a good job. It's a great job. It's a great job. So I don't want pity. You know, my limits are defined by my environment, not by my disability itself. Okay? But this view, the charity model of disability, still exists today as well. Prior to the passage of the Americans with Disabilities Act, in the 1800s, people with disabilities were considered meager, tragic, pitiful individuals. Again, subscribing to the charity model of disability. Unfit and unable to contribute to society except to serve as the ridiculed objects of entertainment in circuses and in sideshows. We're viewed as freaks if we were physically disabled. Thousands were forced to undergo sterilization and forced to enter into institutions and asylums where they lived for the majority of their lives if they got out at all. Prior to the passage of the Americans with Disabilities Act in 1990, there existed in many cities in the United States the ugly laws. Those laws were in place for just over 100 years, from the 1860s until the 1970s. What these laws said is if you were physically deformed, if you had a physical invisible disability, stay off the streets. It made it illegal for people who were physically deformed to be on the streets. It was state-sanctioned discrimination of people with disabilities. The first of these laws appeared in 1867 in San Francisco. And again, if you were visibly disabled, stay off the streets. In my hometown, Chicago's laws, this law was passed in 1911. It was the most infamous. And it stipulated what you see here. No person who's diseased, maimed, mutilated, or in any way deformed, so as to be unsightly or disgusting object or an improper person, is to be allowed on the streets. It made it illegal for somebody with a physical disability to be on the streets. The fine of not less than $1, no more than $50 for each offense. In today's money, that's $23 or $1,200 adjusted for inflation. It was designed to stop us from being on the street and from begging. These laws were in existence just over 100 years, and they shaped how public viewed society and how, conversely, how people with disabilities viewed themselves as well. These ugly laws were not repealed until the 1970s. Chicago's was the last law to be repealed, and that was repealed in 1974. At the same time that we had the ugly laws, we had a eugenics movement in the United States as well, from 1907 to 1963. Eugenics law spread like wildfire. Indiana's was the first law to be enacted. Then 32 other states, including Mississippi, enacted eugenics law. It permitted the forced sterilization of confirmed imbeciles and idiots, people with developmental or intellectual disabilities. It was premised on a philosophy which aimed to improve genetic quality of the human race, determining who should and who should not reproduce. California by far had the largest number of forced sterilizations. They had just over 20,000. The Eugenics Project in Mississippi resulted in a total of 683 sterilizations, mainly individuals who had mental illnesses. They made up 9/10 of the people in Mississippi who were sterilized against their wishes. In 1924 in Virginia, Carrie Buck was the first person to be sterilized under Virginia's law. Now, Carrie was the daughter of Emma. Emma was viewed to be promiscuous because she had Carrie as an illegitimate child. And because of her promiscuity, she was deemed to be mentally unfit and was forced into a home for the epileptics and also the mentally disturbed. When Carrie was 17 years old, she was believed to have inherited these traits because she also had a daughter illegitimately who was named Vivian. Because she was deemed to have inherited these traits, she also was institutionalized with her mom. In Virginia, their eugenics law gave the superintendent of the institution the absolute right to sterilize anybody who he viewed to be unfit for society. He viewed Carrie to be unfit for society and wanted to sterilize her. The law had certain procedural requirements. The superintendent had to petition the board of directors of the institution in order to perform a sterilization against somebody's will. And so he did. And then the law also required that the person who's going to be sterilized to have a guardian or a guardian appointed to them if they didn't have one available. Because Carrie's mom was also institutionalized, she wasn't mentally qualified to be the guardian, so the law required that the superintendent petition the court to appoint a guardian. Once it was in the court system, the guardian challenged eugenics law in Virginia. And so the case made its way through the court system. It finally landed up to the U.S. Supreme Court. There was a trial to determine whether or not Carrie was an imbecile or feeble-minded. Now, these definitions didn't have any real meaning. They were just arbitrary. As a matter of fact, it didn't even apply in Carrie's case because Carrie was an honor roll student. But that was never introduced in the trial. Nor was it introduced to the trial that Carrie was raped. In her foster family, a family member raped Carrie. It was believed because of the shame that would be bring upon the foster family that the foster family deemed her to be of low moral scruples and to be of feeble-minded to get her institutionalized so they could save the name of the family as opposed to saving Carrie. So the case made its way up to the Supreme Court. A very infamous case, Buck versus Bell. Bell is the superintendent of the Virginia institution. In 1927, landmark Supreme Court case. It gave further fuel to the eugenics movement as the court ruled that the state of Virginia could legally sterilize Carrie. It was following this ruling that eugenics movement really took off in the United States. What is telling about this case is the words used by the Chief Justice, Oliver Wendell Holmes. The language reflected society's view of persons with disabilities. In essence, it was better off to let those people not reproduce. Now keep in mind that these laws were in place at the same time eugenics law was taking place. And these laws, to some degree, still exist. They still exist on the books. And what we're finding today is that many medical providers, or certain medical providers, are refusing to provide either sexual counseling, reproductive counseling, or contraceptives to people with disabilities, even thinking that we don't deserve or should be having sex, or we don't need to be having sex. And we have sex aplenty. Thank you very much. After the eugenics movement, another model of disability surfaced, and that's a medical model of disability. And this is a model that is prevalent today. This views not the individuals with disability as having as being evil or being defective, but it views the individual as being the problem. Because I'm a quadriplegic, I am a problem, and I have to fit to society. A physician is the principal decision maker. I can't make decisions on my own. A physician, a doctor, has to make decisions for me. It requires intervention, medical care, medical treatment, physical therapy, occupational therapy, in order for me to conform to society. If they can't fix me, then they'll just try to institutionalize me. I must conform to society. Society doesn't need to be changed in order to fit my needs, and I'm defined by my limitations. This model, I believe, has significant bearing on discrimination that we see in healthcare today, which we're going to talk about in a little bit. It remains prevalent today. An example of how this model shapes policy is that for me to qualify for transportation, for mass transportation, I have to get a medical doctor's certification that the transportation is medically necessary. For you to drive a bus, for you to jump in a cab, you don't need that certification, but I do, and every person who's disabled does, at least in Illinois, and I assume the same thing is true here in Mississippi. If a person needs a power wheelchair and they want a tilt or recline function or an elevation function, as you see with my chair here, they have to prove that's medically necessary, meaning they have to have a doctor say that because of their medical condition, they have to have a tilt function or recline function. It's really not medically necessary, but it's for comfort. If you're in a chair 18, 19 hours a day, you need to be comfortable. Imagine staying in the chair that you're in right now, which doesn't tilt, which doesn't recline, for 18, 19 hours a day. But to get a level of comfort, some level of comfort, I have to get a doctor's permission to do that. Again, that's because the medical model says that I can't make my decisions, that the doctor has to do that for me. Now, a series of events have occurred leading up to the Americans with Disabilities Act that really set the foundation for the disability rights movement. In 1932, Franklin Delano Roosevelt was elected president, re-elected a fourth term until he died in office in 1945. In 1921, he contracted polio, becoming the first public official to become physically disabled. In 1935, he signed the Social Security Act, and that provided Medicare, financial assistance to persons with disabilities, primarily individuals coming back from the war. But it provided financial assistance, permanent financial assistance, for adults with disabilities. In 1962, at the same time that James Meredith was integrating the University of Mississippi for people of color, on the West Coast, Ed Roberts was leading the integration for people with disabilities. Ed Roberts was a student at University of California at Berkeley. He was a person who contracted polio at a young age and resulted in quadriplegia. Ed was dependent upon an iron lung, a machine to allow it to breathe for him. He was admitted to the University of California, Berkeley, and when they admitted him, they said, look, we tried admitting cripples before, but it didn't work. We'll take another chance with you. Instead of being allowed to live in a dormitory like all other students, he had to live in the campus infirmary. After Ed was admitted, a couple more people with disabilities were also admitted who used wheelchairs. Ed went on to lead the movement for independent living and created the first Center for Independent Living in Berkeley, California. A Center for Independent Living is an organization that supports and advocates for the rights of people with disabilities. It is run by persons with disabilities to serve as role models and to serve as peer counselors. But the independent living movement was very instrumental in the passage of the Americans with Disabilities Act and in the disability rights movement. In 1964, when the Civil Rights Act was passed, it eliminated discrimination based on race, color, religion, national origin, and sex. Where's people with disabilities? We were left out of the Civil Rights Act, but the Civil Rights Act became very important in the passage of the Americans with Disabilities Act. We borrowed language from that act. In 1965, Title 19 Social Security Act was passed, and it created Medicaid to provide a federal and state financial assistance program for persons with low income and certain persons with disabilities. In 1968, the Fair Housing Act was passed. Congress passed an act to impose comprehensive solutions to the problem of unlawful discrimination, again, based on race, gender, religion, and national origin, and sex. Where are people with disabilities? Still, in 1968, people were being excluded because we were persons with disabilities. In 1972, Title IX of the Education Amendment Act prohibited discrimination in education, any educational program receiving federal funds, because of gender. There was Section 1684 also prohibited discrimination based on blindness or visual impairment, meaning any university could not use blindness or visual impairment as a basis to disqualify or deny admission to a person who was blind or visually impaired. It didn't mean they had to provide any services or any assistance to those persons. Simply, they couldn't disqualify them for admission simply because they were blind or visually impaired. One of the most important legislations during the 1970s that advanced the rights for people with disabilities was the Rehabilitation Act of 1973. It was a successor statute going back to the 1930s to provide for prosthetics and other equipment and services for returning war veterans. Over the years, the law expanded to include persons with disabilities who were not only war veterans. But in 1973, Section 504 of the Rehabilitation Act was passed, and it opened the doors at federally funded places for Persons with Disabilities Act. 46 words. Section 504 consists of 46 words that was added to this piece of legislation as an afterthought. Everybody in the Nixon administration, everybody in Congress in 1973, because this law was already in existence, just thought it was another renewal for the appropriations. Remember, the Rehabilitation Act was to serve the need primarily of returning war veterans. There was no objection. Everybody supported the Rehabilitation Act. But when Section 504 was enacted, 46 words changed the world for people with disabilities. No other qualified handicapped individual in the United States shall solely by reason of his handicap be excluded from participation in or be denied the benefits of or be subject to discrimination under any program or activity receiving federal financial assistance. In 1973, Greyhound was owned by the federal government. In 1973, there was a significant amount of hospitals that were owned by the federal government outside of the VA system. Every federal building now had to be accessible. Every program held within a federal building had to be accessible. Every university that received federal financial assistance, which was virtually every university, had to be accessible for people with disabilities. When Congress found out that this was in there, and when they found out what it meant, I guarantee you they were shitting in their pants. Because Trailways was screaming, Greyhound was screaming, every company that received federal financial assistance, they were screaming. They said, wait a minute, what does this mean? When a law is enacted, regulations need to be passed to interpret what it means. So what does qualified handicapped person means? What does solely by reason of handicap mean? What does excluded from participation mean? Because everybody realized that they had to become in compliance, and they had to make not only the facilities accessible, but also the services accessible, the regulations took forever to be enacted. The law was passed in 1973. Regulations weren't passed until 1977. When disabilities advocates learned what happened, as then did the Ford administration, everybody was scrambling to take their position. Advocates started to mobilize and started to engage in civil disobedience in order to get the regs finalized. And it occurred all throughout the country. Civil disobedience. There were contradictory rulings being handed down by the courts. There was one case involving, again, transportation on buses, where the court ruled that if a bus pulled up to a bus stop and simply opened its door, whether I could get on or not with my wheelchair didn't make a difference. The fact that the doors were open to me was non-discrimination. Another court on the other side of the country said, no, wait a minute. When the bus stopped and opened its doors because the stairs were there and there wasn't a lift system, that was discrimination. These cases were being tried all throughout the country to determine what the law meant because there was no regulations. Every presidential administration that came in dragged their feet from 1973 to 1977. Again, trying to find out and interpret what this meant because it cost money. Department of Education, of Health, Education, and Welfare was the lead agency. Their regulations have become guidelines for all other federal agencies, including the Department of Transportation, Housing, Urban Development, etc. It was crucial that the initial regulations be strong because it would cover every area that received financial assistance. From 1973 to 1977, as I mentioned, the regulations were not issued, but there were a strong set of regulations that were drafted by the Department of Health and Education and Welfare's Office of Civil Rights. They had draft regulations in place, and they passed it from agency to agency to get approval, and everybody was dragging their feet. So they sent it to the Secretary of Health and Education and Welfare, and he sat on it for a number of years. When they finally sent it out to the public for public comment, they received all kinds of pushback from the business community and from the religious organizations. And there was a federal lawsuit that was filed by disability rights advocates because the regulations were not passed, and the judge ruled in favor of disability rights advocates. It said that the regulations needed to be passed, but he didn't stipulate when they needed to be passed. And again, so additional time kept going by when no regulations were going to be issued. Finally, Health, Education, and Welfare printed the proposed regulations and made it available for public comments. And what resulted was a final comprised set of regulations. We're waiting the Health and Education and Welfare Secretary, then James Califano, with the Carter administration in 1976 and 1977. Once the Carter administration was in office, and this is a Democratic president, instead of signing the regulations, the Health, Education, and Welfare, they set up a task force to study the regulations additionally. Again, from 1973 to 1977, now we're still studying the regulations. But this group that was set up to study regulations didn't include anybody with disability. Again, disability advocates rallied again and were concerned that the regulations are going to be weakened. There was a lot of compromised issues. Universities didn't want to provide accessibility to people with disabilities. So what they proposed to set up a consortium, meaning that universities in a different geographical location could collectively become accessible, meaning that a person in a wheelchair could take one class on one campus, get to another campus and take another class for the same period of day. They found that to be an acceptable solution. As you can imagine, people with disabilities, particularly people in wheelchairs, at that time there weren't a lot of power wheelchairs, were up in arms. Okay? That would not be a reasonable accommodation to allow me or force me to take classes on different campuses during different days and different times. So what the disability community did, they stormed public offices and they stormed federal buildings. They sat in for 28 days in San Francisco, the Health, Education, and Welfare Office in that city. It became so effective that finally regulations were issued. And here you see photos of people in chairs getting arrested in Washington, D.C. Sit-ins throughout federal buildings. In San Francisco's federal building was most effective. It lasted 28 days, finally forcing the signature of the regulations. 200 people with disabilities sat in the Health, Education, and Welfare building in San Francisco. When they thought that the secretary was not going to sign the regulations, they set a vigil outside of his house protesting. They weren't going to just let him not sign the regulations. Finally, the regulations were signed in 1977. Each federal agency then had the obligation to issue their own set of regulations under 504. Common upon that was reasonable accommodation for persons to avoid employment discrimination, communication access for persons who are deaf and hard of hearing, and other things that we're going to talk about in a little bit. It also provided that if you had a claim for employment discrimination, you did not need to get a right to sue letter from any agency before you could take a claim into court. It gave you a private right to sue, which is very important. There are a number of decisions once the regulations were issued that tried to water down the scope and the breadth of what these regulations provided. For instance, in 1984, a Supreme Court decision in Grove City College in Pennsylvania held that when Congress voted to allow withholding of federal funds for an institution that discriminated against people with disabilities, it only applied to the department that received federal financial assistance and not the university in total. Meaning if the history department at USM discriminated against a person with disability, it was the history department that could be punished only and not the broader university. What that meant for me, if I was a plaintiff as a person with disability, I had to follow the flow of federal funds to see whether or not the history department received it. It's very difficult to do. When the law was enacted, when Section 504 was enacted, it stated that if you discriminated or were found to have discriminated against a person with disability, that you could lose your federal funding. And that was a significant punishment, particularly if you relied on federal financial assistance primarily as your only source of funding. But now to say that a court, the Supreme Court, to say it only applied to an individual department was very harmful for plaintiffs' cases. It limited our ability to get redress. Okay? But there were a number of court decisions that are being handed down, again, because there wasn't a lot of background. Typically when laws are enacted, when rules are enacted, there are public debates, there are public hearings. Because Section 504 was an afterthought, there was literally zero in the congressional record to give what the congressional intent was. What did they mean when they said that no qualified handicapped person would be discriminated against on the basis of disability? The Reagan administration was threatening from 1981, from 1983, either to amend or to revoke these regulations. The Reagan administration, when it came into power, what it wanted to do was shrink the burden on businesses, shrink the overreach of federal government. And to do so, people with disabilities who were not well organized on a national level, who did not have national presence and representation, they were the ones that were at the target at the cuts that were being taken place on federal financial assistance. The call for comprehensive integration continued after regulations were enacted. In 1983, Americans Disabled for Accessible Public Transportation, or ADAPT, was organized, and for the next 7 years they staged demonstrations to make sure that public transportations in cities across the nation were integrated. Here you see photos of them chaining themselves together and chaining themselves to buses in Los Angeles and Philadelphia. They've become the radical arm of the disability rights movement today. Today, when you hear of protests and individuals getting arrested, they're members of ADAPT leading the way. Okay? And you can tell it's 1970s because of the boombox they're carrying. More photos of the protests from ADAPT. In 1986, the National Council of the Handicapped issued Towards Independence as a report. The National Council of the Handicapped was an advisory agency to the President and to Congress on issues affecting persons with disabilities. For the longest time, when it was created back in 1980, it did very little to write reports and to influence Congress. The first substantial report it drafted was in 1986 and was Towards Independence. What it did is it gathered all the stories, or the majority of stories of people with disabilities around the country to learn what their discrimination was taking place, even in light of the Section 504 regulations being enacted. This report outlined the status of Americans with disabilities, and it implored for the civil rights and comprehensive federal rights federal civil rights legislation that would ultimately be passed and known as the ADA. In 1988, as a result of this report, draft law was being prepared for the Americans with Disabilities Act. It was not without a fight. It was shepherded through the House and through the Senate by representatives and senators that had a connection to disability. As I mentioned before, it's only when disability becomes personal that people take action. Senator Robert Dole, who was injured during World War II, was himself a person with disability. Edward Kennedy had a sister and also a son who had a disability. Tom Harkin had a brother who was disabled. Every senator, every congressman who signed on to enact the Americans with Disabilities Act had a family member who was disabled. And if it were not for them, then we wouldn't have the Americans with Disabilities Act today. And back in 1989 and 1990, when the law was enacted, when President Bush was president, there was a Democratic Congress in place. They controlled both the House and the Senate. In today's world, it would be very difficult to get the Americans with Disabilities Act passed because of the gridlock that's taken place in Congress. But it was because of this organization, the National Council on Handicap, was very instrumental in getting the ADA passed. You may have heard of the Capitol Crawl. When the ADA bill was making its way through Congress, and finally everybody was in agreement, on March 12, 1990, final touches were being made to the bill and being sent to the President for his signature. On that same day, disability advocates were demonstrating outside of the Capitol in Washington, D.C. Spontaneously, as a sign of protest, they got out of the wheelchairs, they dropped their walkers, they dropped their crutches and their canes, and they crawled up the 100 steps up the Capitol building. Many disability rights advocates say that this is the defining moment in which the Americans with Disabilities Act was signed and was pushed into legislation. But in all honesty, it was already being handed to the President seconds before this took place. So visually, this is a good picture, and it's symbolic of the protest and of the rights that people were trying to fight for, but it did very little to enact legislation. As a matter of fact, you can't point to one single incident, one single episode to say that was the defining moment within the disability rights movement. We don't have a Selma. You know? The closest thing we have is what you see there in the Capitol Crawl. When the ADA was enacted in 1990, it finally repudiated the ugly laws. It promised equality of opportunity and full inclusion for people across all types of disabilities, for millions of people with disabilities. When the ADA was enacted in 1990, there was only 23 million people in the United States that reported as having disability. It intended to pave the road to equality of opportunity and full inclusion, but the ADA does not guarantee it. But it makes it possible. Like the road to the summit that we talked about before, the road to equality of opportunity and full inclusion is steep and is pitched. Not many straightaways and quite a considerable number of curves. There's a general prohibition against discrimination, and there's portions of the law where there should be guardrails, but there's simply not. When the President signed the ADA, he said, "Let the shameful wall of exclusion finally come tumbling down." With today's signing of the landmark Americans with Disabilities Act, every man, woman, and child with a disability can now pass through the once closed doors into a bright new era of equality, independence, and freedom. The law has 5 sections. The main sections are Titles 1, Titles 2, and Title 3. Title 1 prohibits employment discrimination. If you're an employer and you have more than 15 employees, you cannot discriminate against a person because of their disability. You have to provide them reasonable accommodation to ensure that they can do the job with or without the accommodations provided. And when you determine what's reasonable, you look at the financial resources, not only of the employer, but of the broader organization that the employer belongs to. Title 2 prohibits discrimination by public entities. Public entities is any business, any service that's provided by a state, county, city, or any municipality or any agency of a municipality. Title 3 prohibits discrimination by public accommodations. What is a public accommodation? A public accommodation is any business, for-profit or not-for-profit, that opens its doors to the public. Title 3 has a general non-discrimination obligation. It says you can't prohibit against or discriminate on the basis of disability. You have to make sure that your facilities and your services are open and permit people with disabilities to have an equal opportunity to benefit from those services and those facilities. That means if you have to widen doors, if you have to install ramps, if you have to procure special equipment to ensure that your services can be available to people with disabilities, you have to. Now, excluded from this obligation are private clubs and also religious organizations. Religious organizations, they own a significant amount of healthcare systems in the United States. Doesn't mean they can discriminate based on disability, because remember, if they receive federal funds, they're still bound by Section 504 of the Rehabilitation Act. Okay? But Title III regulations don't apply to religious organizations. Along with the general obligations, there are very specific obligations. And that is that public accommodations must modify their policies, their practices and procedures to ensure that they provide care and services for people with disabilities. That means if they have to extend their hours of a doctor's office because I may need additional assistance getting clothes on or clothes off to get an examination, because I may need assistance getting out of my chair onto an examination chair, it means you modify your policies to account for that. It means if I rely on public transportation that gets me there chronically late, make sure that my appointments are either at the end of the day or at a time where you can afford to spend additional time seeing me, to take into account that I may have transportation difficulties. Remove architectural barriers. And that is, if you have to widen doors, make sure I'm able to get in. If you have to put in ramps, you have to make sure that examination rooms, you have to make sure that classrooms are in fact accessible to me, that there are flat surfaces or there's a ramp that I can get in, and I can get underneath desks when I need to. Provide aids and services to effectively communicate. Up front, you see that we have a sign language interpreter. It means that if you're an institution, an educational institution, and we're going to have communication, that you need to provide a sign language interpreter or CART, computer-aided real-time transcription. So if we had CART here, you'd see on another screen, everything as I'm talking would be dictated, and you'd show up on the screen so you could see that in case you had a problem or difficulty hearing. We'll look at some more of these examples of these specific obligations. In 1990, when the ADA was enacted, there was another model of disability that was developed. What makes this model, the independent living model, so different is that it was created by people with disabilities for people with disabilities. It said that the problem is not the individual, that disability is not inherently evil, that we alone are not defective because we have disability. It's that the problem with people with disabilities is our dependence on professionals, our dependence on doctors, our dependence on medical professionals, our dependence on family members, that we need to be independent as individuals as we possibly can. That the individual with a disability is the principal decision maker. That consumer control and peer support is what's going to be helpful to allow us to not only interact with society, but to make changes within society so that society conforms to our needs. That we have to fix the environment, that the environment is not the problem, that the environment is not the only problem, but the environment needs to be fixed. It's not static. If things don't work because I can't get onto the sidewalk, allow for curb cuts to allow me to get on sidewalks. Allow for buses with lifts and with ramps. Fix the environment so that it's accessible to people with disabilities. That disability is a common part of the human condition. We all are going to be disabled. You're disabled when you're born. You're going to be disabled when you age and when you get close to death. We are limited by our environments and by the barriers that exist within the environment, and not because of our disability. So there you have it. 1990, we had our landmark legislation. We had now this independent living model of disability. Our struggles are over. We don't have to fight. We don't have to assert our rights anymore. End of story, right? The furthest can be from the truth. Our struggle continues. I don't want to minimize the struggle of people of color and people and women, because you constantly have to fight for your rights as well. But all that's needed for a change of heart for people of color and for people who are women, in order to receive equality of opportunity and full inclusion, is simply a change of heart. Signs have to come down so that where signs prohibited me from now entering if I was a person of color, I can now enter. A change of heart to include people with disabilities is not enough. We need a change of structure, perhaps a change of building, a change of room, a change of layout, which requires a financial commitment. And because it requires financial commitment, we're finding that we are not being included in all levels of society. Our struggle continues. 25 years, what I can tell you post the passage of the ADA, it's not all full inclusion of equality of opportunity or inclusion altogether. The ADA on paper is like a beautiful sheet of music. It needs to be played in order to be interpreted, and everybody has to do their part. Because we have a law on paper that protects us, that's not enough. As Dr. Martin Luther King Jr. has said, we have to fight for our rights. And just because we have a law on paper doesn't mean that we have rights. If we don't fight for our rights, then we have no rights regardless of what laws may exist or what politicians may say. And so our struggles continue, whether that be in education, whether that be in transportation, whether that be in housing. As you see from these headlines, the headlines that we've seen before, discrimination still occurs. Local developer was discriminated against based on disability at 71 apartment complexes in 4 states. Justice Department just settled a lawsuit with your neighbor city in Petal, Mississippi for discrimination on housing against people with intellectual disabilities. Uber and Airbnb leave disabled people behind. In Chicago, only 3% of the taxi fleet is accessible. 3%. I can't get across town relying upon a cab. Today, persons who are not disabled can just walk out in the street, raise their hand, and get a cab in seconds in Chicago. And now with Uber, they push a button on their app, and a ride shows up. Uber is not accessible to people with disabilities. And then during Sandy, the city in New York failed to provide for people with disabilities. When you look at every major employment or economic indices, you find that people with disabilities are lagging. Our employment rate is not even 1/3 of people with disabilities, without disabilities. Our unemployment rate is twice that of people with disabilities. Earnings difference, $6,000 difference. Household income, difference between the two is $23,000, $23,300. Poverty, 16 percentage point difference. Our struggle continues, whether it's income equality, housing, transportation. However, there's one area where our struggle has life and death consequences, and that's in healthcare. The importance of attaining and maintaining health is important to all of us. But for people with disabilities, it's the predicate to our ability to live, our ability to learn, our ability to earn. We must have access to accessible, barrier-free health care. Even though the law exists, it's not there. When I thought 19 years ago that healthcare would be that one segment of our society that would be welcoming and the furthest from the truth. Remember what I said about the medical model? You either fix or institutionalize. When I go in because I have a chest cold, the first thing the doctor looks at is me in the wheelchair. He sees the disability is not someone I've seen before. If he can't fix me, he'll just move on to somebody else that he can fix. Now, we love that in our doctors. We love that our doctors have the God complex, right? I can cure you, but if I can't cure you, I'm going to move on to those who can. But that problem is providing a hindrance for people with disabilities. Now, I'd be remiss if I didn't take the time in the setting that we're at to spring a quiz on you. Now, I'm not telling you that your ability to eat cake is dependent upon it, but it is. Just 4 quick questions. When can doctors examine the patients in wheelchairs? When can a doctor examine a patient in a wheelchair? Any clue? When? Miss Donna? Whenever they want. That tends to be the reality, whenever they want. I go in for a physical, I need to be on an examination chair to get a complete body physical. Doctor comes, looks at me and says, hey, I assume everything below the waist is acceptable. How am I going to know that? I don't know that. It's critical that I get out of my chair onto an examination chair. When can doctors examine patients in wheelchairs? When it's clinically appropriate. When I go into a clinic for an ear infection, when I go in for my throat, when I go in for chest, because I have chest congestion, it's not clinically inappropriate to examine my wheelchair. But if I go in because I have something going on below my waist, how can you examine me when you examine me in my wheelchair? It's not a thorough medical examination. Only when it's clinically appropriate, yet doctors do it day in, day out. Are doctors' offices required to provide safe patient lifting teams? That is a team that's qualified, that knows how to get me in my chair onto an examination table, onto an x-ray machine, onto a diagnostic equipment. Are they required to do that? The answer is no, right? There are 10 states that have safe patient lifting handling laws. Mississippi is not one of them. Okay? And these are laws that are enacted on behalf of the nursing lobby, because nurses, the number one problem of injury to them is lifting and moving patients. So they lobby to get these safe patient lifting laws, meaning that hospitals and nursing homes have to have safe patient lifting equipment to facilitate the transfer, the safe patient transfer of an individual in a wheelchair or in a scooter. So doctors' offices are not required to provide safe patient lifting teams, only in those states that have safe patient lifting laws. There's only 10 laws and 10 states, and Mississippi is not one of them. When is it permissible for a doctor to require a deaf family member to interpret for the patient? You're shaking your head? Is that?
Yeah, I'm hearing it clear. That's a very personal setting to be a doctor's office.
Okay.
Have a family member translate to you. That's inappropriate.
Yeah, it's not appropriate. So the Department of Justice has no clear regulations that say this. Okay? The regulations say you have to provide effective means of communication to auxiliary aids and services to achieve effective communications, but it doesn't specify how that's going to be done. So when is it permissible for doctors to require a deaf patient's family member to interpret? Only in the event of extreme emergencies and only adult family members. A family member could be too distraught, could be too emotionally involved to interpret correctly or interpret completely. Okay? It's only when it's extreme emergency and there's not a qualified sign language interpreter available, and family members are to be used but used sparingly, and only adult members. Minor children can be used, but again, extreme emergency, but only until a qualified sign language interpreter. Are hospitals required to provide patient escort services to blind patients? If they provided escort services, I'd pretend to be blind to get that. What it means is provide patient escort services, and the answer is they should, if needed, if required. If reasonably required, you have to provide escort from one department from one floor to another. I have a client at Northwestern Memorial Hospital who has to wait anywhere between 45 minutes to an hour and a half to get to the lobby from one floor up. Patient escort services should be provided in a timely fashion. These are examples of reasonable modifications of policies to provide accommodations for persons with disabilities. Again, when I was injured, I thought hospitals would be a haven to us, but it's not. In 2011, there was a healthcare study conducted, and it was determined that across the country, persons with disabilities have a greater propensity for these 7 conditions than persons without disabilities: arthritis, asthma, high cholesterol, blood pressure, diabetes, heart disease, and stroke. What's striking to me is that for the vast majority of these 7 conditions, they can be prevented. And if not prevented, they can be easily detected and then managed once early detected. But because we confront barriers in getting accessible health care, because we're not put on examination chairs, because we're not put on examination tables, because we don't have comprehensive access to barrier-free health care, these things are going undetected. And what's taking place is that for persons with disabilities, health care becomes a disease management as opposed to a disease prevention approach. And that needs to be changed. In 2011, the Equal Rights Center, which is a national group that advocates for the rights of people with disabilities, they conducted a study in 24 states, and they concluded that healthcare providers are ill-prepared to take care of persons with disabilities. When they looked at optometrists, only 20% were able to examine people in their wheelchairs. The problem in an examination chair for optometry is that I need to be transferred onto the examination chair in order to access the equipment. Otherwise, I'm provided a manual examination, which could be effective if the optometrist knows how to do that and has recent experience doing that to get a proper refraction measurement. But chances are they have not had recent experience doing that. Doctors' offices and hospitals are not able to provide information in alternative formats. For people who are blind, for people who have low vision, for people who are deaf and hard of hearing, they're not providing information in Braille. They're not providing information in large print. They're not providing to them electronic format. They're not providing interpreters when required. Pharmacies are not offering Braille or audible information for prescriptions. There exists technology today. When you get greeting cards, I'm sure all of you either bought them or received them. When you open up, there's a cute joke that's said to you. There's a song that's being sung to you because of a little microchip. That same technology is now being used to create talking prescription labels on medication vials. Because what the blind are being forced to do right now, they're either forced to memorize the feel and shape of their medication, or they use a rubber band system to distinguish one medication vial from the other. And that is one vial will have one rubber band on it, another vial will have two rubber bands on it, the third vial will have three rubber bands on it. Again, it's incomprehensible to me the things they have to go to. Or they have to call a neighbor or have a family member read to them that what is on the prescription vial. Another study in 2013 that shows that people can't get transferred, buildings are not accessible, and height-adjustable examination tables are not being used. Again, these are all barriers to health care. These are all violations of the Americans with Disabilities Act and also Section 504 of the Rehabilitation Act. The problem exists despite 25 years passage. Again, recent headlines. Major cities, major hospitals discriminate against people with disabilities. Healthcare providers are required to modify their policies, practices, procedures. As we mentioned, one area where they need to modify their policies, practices, procedures is in the use of service animals. In 2008, the regulations were changed to define what a service animal is. Before, it used to be a rat, a ferret, a monkey, a pig, a snake. Service animal was any animal that was trained that could perform a function to support a person with disability. It got so out of hand, again, anything was being brought into doctors' offices and all over the place. Again, every public accommodation, restaurants were having to allow these animals in their facilities because it was a public accommodation. When the regulations were enacted, we said goodbye to the mouse, the ferret, and the monkey. Today, only dogs that are trained to perform services to people with disabilities are considered service animals. Okay? Now, miniature horses are also recognized under the regulations as being animals that support people with disabilities, and they can be allowed in facilities as well if they're properly trained and if they're under control of their handlers. So today, only dogs that are trained and also miniature horses. Now, the dogs don't have to have a vest, they don't have to have paperwork with them, and doctors and other public accommodations are only required to ask two questions. That is that a service animal needed because of disability? And if so, what can the dog do? They can't ask if you're disabled, they can't ask for papers, they can't ask for demonstrations, they can't ask for proof. Apart from modifying the policy, practice, procedures, they must remove accessibility barriers for people who have mobility impairments. These doors are very difficult to get into unless I have someone with me to allow me in. Changing room, I can't get in there at all. Examination room, very difficult for me to get into. Once I'm in there, I can't maneuver. And once I'm in there, a lift equipment can't go in there to facilitate my transfer onto an examination table. Examination tables need to be height adjustable. If I'm going to be carried onto that, if they're going to be using lift equipment, if I'm going to transfer independently, I need it to lower at least 17 to 19 inches above the finished floor. My patient rooms need to be accessible as well so I can get in and out. The biggest problem for people with mobility impairments is we're simply not getting weighed. There's an absence of wheelchair accessible weight scales. If I can't get onto that traditional scale, then doctors are either asking me for my weight, which I'm guessing, or they're using their previous recorded weight that could be grossly inaccurate. For people who are deaf and hard of hearing, so pregnant pause is awkward, but if you're deaf, imagine not being able to hear and listen and understand what the doctor's telling you. Imagine not being able to convey what your medical symptoms are. Imagine not being able to understand what's taking place with a loved one. Can you see this note? Because this note was given to a client of mine after his wife was in emergency surgery for 6 hours. He didn't know where she was. They're both deaf. He was asking for a sign language interpreter, trying to find out where his wife was, what room she was taken into. He didn't know she required emergency surgery. After 6 hours, he finally found out that she was in surgery. Before the doctor came out, he was so upset not knowing where she was, he was banging on the information desk. And the information desk kept on nodding to him, saying they're going to bring a sign language interpreter. What they brought were security guards to escort him out of the building. When a social worker finally intervened, found out what was taking place, took him up to where his wife was, coming out of recovery, the doctor came out of surgery and handed him that note and just walked away. The problem with people who are deaf, you would think that maybe this would be helpful, a written note, but if you're not mainstreamed in the educational system, then it's likely you're going to have a 4th and 5th reading grade level English language. You're not always going to understand what's being written. Effective communication under the Americans with Disabilities Act requires that doctors provide auxiliary aids and services, which often means an on-site sign language interpreter or a sign language interpreter that's available through video remote interpreting. Written notes is not enough. And again, for persons who are blind or visually impaired, it requires that they provide information and materials that are in alternative formats, whether it's large print, whether it's electronic format, whether it's forms that can be read by individual screen readers. Those things need to be provided. And again, Walgreens in 2014 adopted the talking pill reminder. It's technology that is added to the bottom of the medication vial, and with one turn of a wrist, it activates a chip that tells the information that the patient needs to know about what the pill is, when to take it, what the side effects are, etc. All other pharmacies are now adopting that technology. They're not doing it because they're good people. They're not doing it because they're good corporate citizens. It took the work of disability advocates, friends of mine on the West Coast, to advocate for that to take place, either through the threat of lawsuit or because of a formal structured negotiations. Persons with intellectual and developmental disabilities, they suffer the same type of discrimination that we do if they have also mobility impairments. Right? The same types. But this group suffers from the lack of cultural competent care. And what I mean by cultural competent care, that means care that's disability specific. So a doctor knows the difference between autism and another form of developmental disability. That doctor knows the difference between spinal cord injury from muscular dystrophy, from spinal cord injury from MS. Care that's catered towards me and my disability, and that doctors know what needs to take place. More help is coming. The Affordable Care Act. For the first time, the Affordable Care Act designated people with disabilities as being a minority group for purposes of research. It is critically important. Being identified as a minority group, when it comes to disability studies and healthcare studies, you get funding for being a minority group. Researchers get funding to study the care that's needed for minority groups. And the Affordable Care Act designates us for persons as a disability group for purposes of research. It directed the U.S. Access Board to come up with standards for accessible medical equipment and furniture. So it tells doctors and officers that they have to buy accessible examination tables, they have to buy accessible wheelchair weight scales, they have to buy lift equipment, etc. And it set the standards for what that was. But the problem is that these standards were supposed to be in place by 2012. It took the U.S. Access Board until 2014 to come up with the standards, and now the Department of Justice has them. And it's going to take forever, as it usually does, for them to adopt regulations. Once the regulations are in place, then everybody has to abide by them. And hospitals and doctors and schools of medicine, schools of dentistry, schools of nursing have to adopt curriculum that is culturally competent for their residents and for their students. They have to teach disability information to their doctors and to the residents, which means if you're an advocacy organization, if you're a support organization in the community, this is a potential stream of income for you because they don't know how to do that themselves. Okay? This is an educational and a economic opportunity for others as well. The Department of Justice took great interest in accessible health care. In 2012, it launched its barrier-free healthcare initiative. It was a very concerted effort on behalf of Department of Justice to say, we're going to stop discrimination in the area of healthcare. Right? So it teamed up with U.S. attorneys throughout the country to enforce 504 and to enforce the Americans with Disabilities Act against healthcare institutions. In 1997 through the present, there have been 36 actions that were initiated aimed at healthcare discrimination, and of the 36, 27 of them, that's just over 75%, were aimed towards communication access. That is access for people who are deaf and hard of hearing, and access issues for persons who are blind or visually impaired. The problem with the Department of Justice is that they tend to take individual actions. They tend to take actions to enforce the law against individual hospitals, against individual doctors' offices, against individual dental practices. While private attorneys like myself and other attorneys are doing the large healthcare systems, justice is focused on the one-ons. It seems backwards to me. Justice should be taking steps to ensure that there's systemic changes taking place within the healthcare industry, but they simply don't have the resources or the time to do that. So that leaves room for private attorneys like myself and others to take action. This leads us back to where we started. The reservoir in the background is where we started, where we began our walk, our climb up Pikes Peak. 13 miles in just over 6 hours. The road to equality of opportunity and full inclusion is long. But the road to equality of opportunity and full inclusion is wide. And it is that way because we need to travel upon it together. Not only the disabled, but also the able as well, because we can't do it alone. We need the assistance of people who are interested to take disability issues to be a personal issue, to get involved and help enact laws and enforce laws to make some changes. We also need help spreading the message. And the message of the disability community is this, and that is because we're blind, it doesn't mean that we don't have a vision of who we are, and what we want to be. Because we're deaf, it doesn't mean that we don't need to be listened to. Because we can't speak, it doesn't mean that we don't have a voice. And because we can't walk, it doesn't mean that we don't want to move forward. We need your help to help spread that word. And I hope that you would take personal interest in disability issues, because disability issues are issues that affect every single family and every single community. And with that, I thank you so very much for having me and for being a very patient audience with me this afternoon. Thank you.
Thank you, everybody, for coming. We certainly appreciate Andres and his beautiful wife coming from Chicago.
Thank you so very much.
With us this afternoon. Please, as you leave,